This video is about my book, How to Sue the Government. This is chapters 6 and 7. These are short chapters, but chapter 6 is quite important. It's about statutes that enable suing the federal government. In addition to finding the laws that apply to your case, you'll need to cite a statute that enables suing the federal government. The United States may not be sued unless federal legislation specifically authorizes the suit. The sovereign immunity of the United States government is firmly established. If you don't cite the right statutes here, the judge will dismiss your case. Luckily, there are only 3 such statutes for federal question jurisdiction. The Administrative Procedures Act, or APA, which is 5 U.S.C. Section 555, allows judges to compel federal agencies to do something or to not do something. This is called injunctive relief. The APA does not authorize money damages as a remedy. Discovery is not available in APA cases. Jury trials are not permitted, and APA cases are heard in U.S. District Court. The Tucker Act, which is 28 U.S.C. Section 1491, is for breach of contract. Money damages over $10,000 are permitted. Limited injunctive relief has recently been permitted. A 6-year statute of limitations applies. The Tucker Act covers explicit contracts, a written contract signed that both parties signed, and implicit contracts. Discovery is available in Tucker cases. Jury trials are not permitted, and Tucker cases are heard in the Court of Federal Claims. The third statute that enables us to sue the federal government is the Federal Tort Claims Act, or FTCA, which is 28 U.S.C. Part 6, Chapter 171, and 28 U.S.C. Section 1346. The FTCA covers wrongful acts or infringement of rights committed by employees of federal agencies. The agency is the defendant, not the employees. The FTCA permits money damages as a remedy. Claims must be filed within 2 years of the events. Interest isn't allowed. Torts are mostly personal injury cases. Jury trials are not permitted in the Court of Federal Claims. Here's FTCA cases. There's also a little Tucker Act for U.S. District Court to hear cases in which monetary damages are under $10,000. Jury trials are not permitted. You may have to file 2 cases in 2 courts. You might file under the APA, asking the judge to order an agency to do something or to not do something. Then you file under the Tucker Act for monetary damages. Some government corporations lack sovereign immunity. The most frequently sued of these is the Postal Service. Others include the Federal Deposit Insurance Corporation, the Pension Benefit Guarantee Corporation, the Export-Import Bank, and the Tennessee Valley Authority. These are corporate entities separate and distinct from the federal government. Now I'm going to talk about what is a contract. The Tucker Act is for contracts that are either express or implied in fact, not for contracts that are implied in law. For an implied in fact contract, there must be an offer, an acceptance of the offer, mutual agreement, and consideration. The terms and execution of the agreement will be evidenced by the behavior of the parties involved. For an implied in law contract, circumstances form the contract rather than intent. This can be a key distinction if you're suing a federal agency for money damages. If you didn't sign an explicit written contract with the agency, you'll need to show in your complaint that the agency made an offer, you accepted the offer, there was mutual agreement, and you provided consideration, something of value, to the agency. For example, the agency's offer, the National Science Foundation published a grant solicitation for scientists to apply for $275,000 grants. Plaintiff accepted offer. I downloaded the solicitation and read that applying for a grant is a two-step process. First, I had to send in a 3,000-word project pitch. Mutual agreement between agency and plaintiff. A National Science Foundation program director accepted my project pitch with an email saying that my scientific research was appropriate for the National Science Foundation. And finally, the plaintiff's consideration. I spent about 100 hours writing my grant application, plus I paid a freelance grant writing consultant $1,000 to edit my grant application before submitting my proposal to the agency. This is an implied in fact contract. Both parties intended to work together to do something. In an implied in law contract or quasi-contract, neither party intended to work together, but circumstances put them together. One party or both parties worked, and one party benefited from the other's work. You can't sue the government for an implied in law contract. Now I'm going to talk about what is discovery. Many, if not most, lawsuits involve documents or other information produced by the defendant. The plaintiff needs this evidence to prove their lawsuit. Most jurisdictions allow each party to request evidentiary documents from the other side under discovery. Collecting evidence to prove your claims is likely to be how you spend the bulk of your time on your case. The Tucker Act allows discovery. The APA doesn't allow discovery. The FTCA allows discovery in some cases, depending on when the claimant knew or should have known that an injury was caused by negligence. Before you file your lawsuit, file an Freedom of Information Act FOIA request for your documents. FOIA requests are cheap and easy and should take 3 or 4 months or less. You must also follow federal court rules, including the Federal Rules of Civil Procedure, the Federal Rules of Evidence, your district court's local rules. Find these on the Clerk of the Court's website. Judicial practice standards. Each judge can make rules that apply only in their cases, such as the maximum number of words in a motion, the font and line spacing, etc. Find these on the Clerk of the Court's website. And lastly, forms approved for use in your district. Get the forms at the Clerk of the Court's website. If your address changes, tell the Clerk of the Court within 5 days. If you don't, the court could fine you or dismiss your case. And then last part of this chapter, if you follow your Clerk of the Court's guide for pro se plaintiffs and nolo presses represent yourself in court, and call the clerk when you have a question, you likely won't need to read the rules of civil procedure or the rules of evidence. But if you have a question about which court is for which type of lawsuit, what documents must be filed, time limits, discovery, enforcing a judgment, or appealing a judgment, look in the rules of civil procedure or the rules of evidence. And if you're filing a lawsuit against your state government, each state has its own rules of evidence. That's the end of my chapters 6 and 7 of my book, How to Sue the Government. Look below the video for a link to buy my book on Amazon, and look for a button to click to watch the next video. And please click the subscribe button below the video so that I get a share of the revenue from the ads you've seen. I also have a Facebook page, How to Sue the Government, and I'm on X following the hashtag how to sue the government. And my website is howtosuethegovernment.com.